So, dear Ian, welcome. Ian Brown is one of the leading voices when it comes to interoperability, AI, and competition in Europe. And he was quite influential when it comes to the Digital Markets Act in Europe, but also you've been contacted in many instances also in Germany for many issues related to competition and privacy policy. Ian, we've been in the interesting phase in Europe where we have many legislation coming across. What's your feeling? Where should we go further?
It's almost hard to keep track of all the legislation, and the AI Act, of course. I hope over the next couple of years we will see them all start to have a big impact. There certainly is scope within the DMA for the Commission over time if it wants to go further. So for example, the first review the Commission will have to do by 2026. One of the questions they have to answer is, should the messaging interoperability obligation be extended to social networking services, which was something the European Parliament wanted right from the start. And I think what's been happening with Twitter is perhaps a demonstration that might be a good idea. Twitter is a bit smaller than the really biggest gatekeepers, but I think under the qualitative designation criteria in the DMA, I think Twitter could be designated as a gatekeeper. So I think that would be a powerful way to reduce the market power, which has allowed Twitter to very significantly reduce its quality whilst keeping most of its users for now. I think alongside that, what's happening with the AI Act has been focused more on the safety aspects of AI rather than the competition aspects. I think the DMA does cover cloud computing, and cloud processing is a really important part of AI and competition, because we already see, especially Microsoft and Amazon have commanding positions in the cloud computing market, and to a smaller extent Google. They all, of course, are working on AI as well, and cloud capability will be really critical for the big AI actors of the future. So I think that might be one place the Commission over time might say, okay, with the DMA, with the Data Act, have we gone far enough in ensuring the cloud market is competitive? Because if it's not, that will cause problems for competition with AI also.
Just a spontaneous question, because you stress the cloud market, and you know the European initiatives around Gaia-X, etc. Do you believe we need to reconsider our policies when it comes to cloud in Europe, and maybe we should try some industrial approach?
I think Gaia-X has gone in a number of different directions, and I've seen criticisms of it that now apparently it looks like some of the big US companies are going to be very, very involved, and how far that matches up with ideas about strategic autonomy and digital sovereignty, I think is a big question. I think the privacy issues are still there. We know, going back to the Edward Snowden leaks 10 years ago now, the ability, the US government has a lot of power in terms of surveillance via the computing systems of the big companies that are headquartered in the US, and whether European governments, for example, really want to be putting sensitive government data on services controlled by non-European businesses, I think remains a big open question. We've also seen how difficult it is for European competitors to break into these markets, I think partly because of the factors we're all now very familiar with digital markets, which the Digital Markets Act is trying to address. Whether you can overcome those through industrial policy equivalence, I don't think we have a clear answer yet. I think there are going to be many of the same issues with semiconductors, which obviously the US and Europe are now putting a lot of money into, but that is an industry clearly where there are gigantic efficiencies of scale, and how much it's going to cost Europe as a whole to be funding these fabs in Europe, and potentially higher costs and perhaps lower quality of the products that come out of those industrial policy-backed instruments, I think remains to be seen.
But are good interoperability remedies a kind of replacement for the privacy aspect?
No, I don't think, I always stress when I talk about interoperability, it's not a replacement for other aspects of internet regulation, including privacy, and actually making interoperability work in a way that makes individual users comfortable with it very much depends on protecting their privacy, that they're not concerned that by linking up their messenger software or perhaps linking up social networking software, they're going to lose control of their data to other firms whose privacy policies they have not explicitly themselves signed up to. We see that actually right now with a lot of the debate over Meta's new Twitter clone, Threads, and I've seen a lot of people, especially on Mastodon, on the decentralized open social network, which is another alternative to Twitter, say, I feel very uncomfortable about my Mastodon server connecting to Meta's Threads server, which will be technically possible in a few weeks' time, according to Meta. And one of the things I say in response to those concerns is, well, in Europe, the GDPR, is there protecting your privacy. So even if Meta technically was getting access to some of their posts via interoperable technical channels, Meta would not be allowed to process them, to profile that data, to try to target them with adverts, for example. And actually, so far, Meta is not launching Threads in Europe precisely because Meta is not certain yet that they can meet the standards of the GDPR. And I think I've seen a small number of people say, well, that shows the GDPR goes too far. I would say, no, actually, I think it shows the opposite. I think it shows the GDPR has succeeded in making Meta think carefully about the privacy aspects of their service before they launch it in Europe.
We talked to Konrad-Adenauer a couple of weeks ago, and he was quite critical when it comes to implementing interoperability based on the DMA in Europe. He thought maybe it would be a better idea to start with social media instead of interpersonal messaging services. Is he right? Why he has some worries?
I can see that perspective, and certainly I think social media, in the sense of most tweets are public. You can make your Twitter account private, but most people don't. Most people broadcast their tweets to the world. They want people to hear them. They don't have the privacy concerns with their tweets that they might have with their WhatsApp messages, for example. So I can see why Corey and others have said actually interoperability would be easier with social networking services. I think the European Parliament was right to ask for both. It's a shame in the final negotiations they couldn't persuade the EU Council of that. But I think the European Parliament is interested in revisiting this.
But no worries for interpersonal messages which are encrypted?
No, I think actually if you look at how that Article 7 of the DMA is drafted, it's done very carefully. There are a lot of specific protections in there to preserve the level of security and integrity in messaging systems, to make sure end-to-end encryption is maintained. I know from a technical perspective, because that's actually my background, it's perfectly possible to have interoperable end-to-end encrypted messaging. Yeah. So I look forward to seeing it next year, hopefully.
Okay, related issue to encryption. You are following the discussion when it comes to CMA, the regulation that is currently under discussion in Europe. The right to privacy is not an absolute right, and we are witnessing that enforcement agencies are having big troubles when it comes to criminal enforcement. And now we have protection of children in the online sphere. What would be the middle way? Is there any middle way when it comes to encrypted communication and the protection of legitimate interest?
And part of the problem here is there isn't an easy trade-off. You can't just make your encrypted software just a little bit less encrypted in a way that only the police are able to access it, or in the child sexual abuse regulation debate, that the hardware and software companies like Apple, like Meta with WhatsApp, can scan on the phones for one type of illegal content, such as child sexual abuse imagery, but not create a potential backdoor for all kinds of other government surveillance, especially in authoritarian countries rather than in democracies. I think it's a very difficult It's a very difficult question for that reason. I think there are things that can be done by companies like Meta and Apple, and many of which they already do in terms on a voluntary basis, and putting those behaviours into statute is a good thing. For example, they can look at metadata, because end-to-end encrypted messaging still leaves some metadata available to messaging providers. They could look, for example, for individual users that seem to be contacting a lot of children that they hadn't previously been connected with, and treating that as a warning flag. They can make it as easy as possible for children who are using these systems to report cases of harassment and abuse if they're receiving content from people they don't know that's illegal. And then, of course, once the police have that, they can take action. But there isn't an easy answer, I think, on that. And I of course, it's an abhorrent crime, and I quite understand why police and children's rights advocates are calling very strongly for this regulation. But equally, I see the point of the security advocates saying you can't just make a tiny little change here and enable potential child sexual abuse imagery to be scanned or to be decrypted, but not everything else. That's the technical difficulty.
And basically, even if you have enough legal safeguards, the situation remain the same.
The problem with the legal safeguards, of course, is even in democracies, sometimes those safeguards are not fully respected. I mean, we've seen, even just recently, in Spain, there have been a number of credible allegations that the government was eavesdropping on opposition politicians, which you would hope the law would not have allowed, but it has still happened. We saw, to give you another example, there were allegations that lawful interception capabilities in mobile phone networks were being abused in Greece to spy on quite senior politicians. It's still not entirely clear who that was done by, and there have been allegations more recently that the Greek government has been misusing surveillance powers. So even in the liberal democracies, legal protections on their own, you have to be slightly cautious about. Of course, the even bigger problem is these are technologies that are available globally, and they're going to be available in all sorts of non-liberal democracies, and then that can potentially be very, very dangerous for political activists, for example, for opposition activists in authoritarian regimes.
Interestingly, in this case, Facebook is cooperating quite properly when it comes to delivering all the materials that are of relevance for the investigators. Another issue connected to Meta these days, really creating headlines, is the issue that Meta lost the battle in front of the European Court of Justice. Basically saying the Federal Cartel Office in Germany was right, enforcing data privacy also in competition cases. What would be the lesson for the rest of Europe?
The Bundeskartellamt, I think, has been a really leading competition authority in Europe, and this is one of the cases, I think, where they've really sort of pushed the boundaries of antitrust law, and I think in a very positive way, thinking about, is privacy abuse an abuse of dominance as well as being a breach of the GDPR? And I think, I'm glad to see the Court of Justice has agreed with them and said, yes, it is. We've seen similar arguments in other jurisdictions, so that are not strictly bound by that Court of Justice precedent. So in the UK, for example, there is a claim against Meta in the Competition Appeal Tribunal with some similar features to this, which so far, more because the UK collective action legal regime is very new, has not progressed very quickly because it's a collective action, but we'll see if the UK courts are inspired by the Court of Justice, even if they're no longer bound by the Court of Justice's decision. And I think in general, the sort of convergence of antitrust, of privacy and data protection, of consumer protection law, and safety laws like the Digital Services Act, I think is really important. And I think it's something we've seen a bit of in the UK, where the different regulators have a formal cooperation agreement and small body which collaborates between them. And I think it's something that would be very positive if European countries were doing more of that as well. And the DSA and the DMA will encourage them to do that.
Maybe a very last question. You've been consulting also the UK government on AI and supply chains. We've been talking a lot these days when it comes to foundation models, and we have the best example of OpenAI and ChatGPT. There is a kind of challenge in allocating responsibility. Why is that?
Obviously, AI is a very broad technology. It can be used in many different ways, and regulating it close to the customer, I think, makes sense, generally speaking. The complication that foundation models bring is they may be several hops back up a supply chain, you can imagine, because yes, OpenAI, for example, is making ChatGPT directly available to the public as a chatbot. I mean, really more as a technology demonstrator than anything else. But there will be many businesses in future that are paying OpenAI directly, or perhaps even via one or two businesses in between, to bring their technology into their own, just to pick one of a million examples, a bank that is receiving applications for credit, for mortgages, might use foundation models to do some of the assessment of the application. It will be the bank that is directly dealing with the customer, and that will be by and large responsible under the AI Act and similar approaches. But the problem with saying, okay, well, foundation models are back here, we're gonna put the responsibility on the bank in this case to deal with OpenAI or Google by contract or by some other mechanism to make sure if there are faults in the foundation model that turn into problems for consumers, that the bank here is in a position to remedy them. There are two problems with that approach, however. One is very often the bank or other business dealing directly with the consumer will be much smaller than the giant companies that we know are the ones currently making the biggest strides with foundation models. So the balance of power between those businesses is not necessarily going to make it easy for the business with the relationship with the end customer to have problems fixed upstream. We see this equivalent with cloud computing a lot, where organizations using cloud services would like perhaps to change some of the features of the contract that they have with the cloud provider, often to do with privacy, for example. And the cloud providers just say, we're not willing to do that. Sorry, you're too small of a business for us to negotiate custom contracts with you. You either accept our standard contract or you don't use our services. That's it. And I wouldn't be surprised if we see that happening with AI as well, without specific government regulatory attention. The other problem with an approach that's focused entirely on the business dealing with end customers is it may be very inefficient, because there will be some problems with foundation models that you could imagine, a foundation model might be being used by thousands, tens of thousands, millions of businesses actually in the future. And if there are problems in the foundation model that are, for example, widespread bias perhaps against women, perhaps against people from specific ethnic minorities in gaining access to credit, in getting jobs, there will be all sorts of things. People in future, their lives can be very significantly affected by decisions made with support from AI systems. Those biases might be affecting hundreds of thousands of businesses. It's going to be very inefficient for each of those businesses individually to try to take action to deal with some of these defects, rather than having the people who are actually running the foundation model, who are in the best place to fix problems with the foundation model, because obviously they know much more about it than the end user businesses that are just contracting with them to receive services. So I think, therefore, the last minute amendments to the AI Act, which the European Parliament has proposed, that try to put some responsibilities back onto foundation model providers, I think makes sense. I'm sure they'll be tweaked in the final negotiations with the EU Council, But I don't think just saying, sorry, the foundation models are back here, they're too difficult to deal with right now. I don't think that's a sensible approach.
Your feeling, are you considering them as a potential gatekeeper?
I think they, especially because of the link with cloud computing, I think they, and the tipped market we already see in cloud services, I would not be at all surprised if we end up seeing big AI companies as gatekeepers in that role. I wouldn't be surprised if at some point in the next few years the European Commission goes through the process in the DMA to add AI or some very specific type of AI as a new core platform service that is explicitly covered by the DMA. Even before that, they may well start using the fact cloud services are explicitly in the DMA and also in the Data Act, of course. They may try dealing with some of the problem that route.
So let's hope that the European Commission is reading Politische Meinung.
And, I'm sure they are.
Yeah, and it's a kind of special day because we have the new legislation in Germany dealing also with market investigation, but we're gonna comment on this issue on some other occasion. It was really great having you, and many, many thanks.
Thank you.
Die politische Meinung. Neutral geht gar nicht. Ein Videopodcast der Konrad-Adenauer-Stiftung.